Here again, my name is David Firm, and I'm an attorney here with Altitude Community Law. As you know, on your screen, if you haven't joined us before, you'll see a PowerPoint presentation in the center of the screen. It should be taking up most of the screen. There should also be a small box on the right-hand side of the screen with the video feed. That's me. On the left side of the menu, on the left side of the screen, you're going to see a menu. Please select the question and answer icon and type all of your questions there, which will be addressed usually at the end of the webinar. But if you guys have taken a class with me or sat through any of my webinars, you'll know I have no problem kind of stopping, being interrupted, answering questions as they pop up, because again, I'm here for you and I want to make sure you guys are getting the information you need. And if you've got a question, somebody else has got a question. So I like to kind of have that dialogue with you. So, and I apologize for that. Let me get rid of that. There we go. So CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report, and will be sent via email within 48 hours following the webinar. So if you're here for CMCA credits, you get an email within 48 hours. Remember, these are not transferable. You have to attend the webinar and you have to be there for them. Please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about receiving your CMCA credits or your certificates, or quite frankly, anything having to do with this presentation. And with all of that record keeping done, we're off at the races. First, I need to give you the disclaimer, of course, that I am not your personal attorney. If any questions come up during this, much of this is document specific. Much of this really is somebody's going to have to look at your documents. So remember, I'm not giving legal advice. We're talking very general. We're talking very high level stuff. And if you need to actually have an attorney look at stuff, please reach out. We'd be more than happy to answer questions and look at documents as needed. So the topic of can we be more restrictive? How the laws, declaration, and rules stack up against each other, how they intertwine, interplay, and what you do with each of them. Of course, that was much too long a title, so we just stuck with can we be more restrictive? In looking at it, you have to first establish the hierarchy of laws in the governing document and what they do and how they, again, how they interrelate, how they interplay. And we want to make sure that when you go through this, you understand that, oh, if there's something in a higher priority document, typically that document's going to hold true. Or it may establish a limit or a kind of a range of things you can do, and then you quite possibly can be more restrictive, less restrictive. It all depends on the governing documents and the statute in play. So let's take a look down memory lane. Hierarchy of your governing documents. Which document controls? Well, obviously, you have the Constitution of the United States of America. That is the supreme document that controls just about everything the country does. But if you look at a lot of the provisions in the Constitution, they state, such as the First Amendment, the freedom of speech, no government shall do X, Y, and Z. No government shall, or no state shall restrict or infringe the freedom of speech. The right to bear arms shall not be abridged by a government. So a lot of that is limited to what the government can and can't do, even though many people come up and say, well, this is a matter of freedom of speech. I can do whatever I want. That is not necessarily true, because as a small, closely held nonprofit corporation, you can be more restrictive than the United States Constitution. But that is the basis of the document there. Federal law. Federal law is going to trump anything the state does, for the most part. And that's where you come in with the Fair Housing Act, with the Americans with Disabilities Act. How those interplay into you, can you be more restrictive than the mandates of those? Probably not. Can you be least restrictive? Probably not. Those documents say what they say, and they stick right there with you. You have state law, and this is a funny thing. And I put the Colorado Common Interest Ownership Act first because there's this one little provision in the Colorado Common Interest Ownership Act that states this statute trumps or supersedes any other laws passed now or may be passed in the future. So I can make a really good argument that the Colorado Common Interest Ownership Act trumps just about everything else in the state in provisions or areas that it conflicts with other laws. Again, not that it doesn't a whole lot, but there are some that it does. So we need to make sure that we adhere to that, and we need to make sure that we understand exactly what Kiowa says. More on the state laws, and these are some of your forgotten state laws, not necessarily the Colorado Revised Nonprofit Corporation Act, which has, again, getting back to Kiowa trumps certain provisions in the Nonprofit Act, but then the Nonprofit Act is going to control just about everything else you do. You have the Colorado Fair Housing Act. That is the state version of the federal act. A lot of times we get stuck on what the federal act says, but the state actually expands what the federal act does, and there are a few additional protected classes that are set forth in the Colorado Fair Housing Act. 2 new ones were added just this year, and that's the gender equity and gender identification. Those are both now protected classes. How somebody views themselves, you cannot discriminate against somebody based on that. We talked last month about what that may or may not mean to you, so we can, again, we won't go down that path just yet. The Colorado Clean Air Act. Yes, it actually is a thing, and yes, it does impact community associations because, excuse me, it contains provisions that state that an owner, you cannot smoke inside an enclosed building, and it includes condominium associations, high-rise condominium associations, or if you have a clubhouse. Your clubhouse is smoke-free, maybe not necessarily by operation of your declaration or operation of your rules and regulations, but it is smoke-free because of the operation of the Colorado Clean Air Act. You cannot smoke in hallways, corridors, elevators, or within 25 feet of an entry door. And the entry door is defined as, the entry into the community as a whole. So that statute does impact and does give you a buffer. Can you be more restrictive of that? Well, quite probably. You can make all of your common areas not. So these are things that you have to think about, again, when we go down this path. The Colorado Condominium Act, I put it in there because, yes, it's still a thing. If you are a pre-Kiowa community and your documents were created under the auspices of the Colorado Condominium Act, if you're going to amend and restate those documents, you need to make sure that they are written in compliance with the Colorado Condominium Act unless you are opting into Kiowa. So again, these are certain things, certain nuances that you just need to be made aware of. And yes, they still impact your community. Then going down the path, you've got local ordinances. You've got, we came from the state and now we're going local. And the local, what does the local ordinances do? Well, it includes zoning. You could be in a multifamily zoning, which allows for the condominiums, allows for townhouses. R1, which is an old zoning designation of residential 1, and it's, quite frankly, it's large lot or medium lot, single family detached dwellings. What does that zoning allow for? What can an owner do within that property? Planned unit development. Planned unit development, or PUD, is really just a form of zoning, but it's a flexible form of zoning because in the, coming through the 70s to the late 80s or the mid 80s, government started to realize these very strict zoning classifications. Commercial 1, commercial 2, multifamily, R1, residential 1 to R3, whatever kind of zoning you had, were very restrictive and not flexible. So they came up with this concept of the planned unit development. And the planned unit development is put on an entire piece of property, and it includes just about everything else you can do or everything you can do in that property. Now, can you do something that violates that planned unit development? No, you can't. That's your local zoning. And if you try and do something that violates it, it wouldn't be allowed. So again, some of these times you have to actually go back and look at your PUD and find out what's allowed in your PUD. And can you be more restrictive than the provisions in that? It's, again, this is going to have to go over some of these things. Your official development plan. Well, you have a PUD, that is the zoning on the entire property, and then you actually have an official development plan that's approved as to what can be built on a specific phase or a specific lot and block or a specific piece of the property in that community. And this is going to include landscape plans. It's going to include the size of houses and the setbacks and things like that. So it becomes an issue. Another thing that comes up a lot is, particularly now, is auxiliary dwelling units. Are they permitted in your community? If they are permitted, can you restrict them further in your covenants? And we'll get into that in just a second. So these are some of the things that we go down the path of trying to figure out as we work through these documents. Like I said, landscape plans. There is actually a landscape plan for almost every community out there, and it says what type of trees, how many bushes are to be planted where. And as communities age, everybody forgets it's out there, including, quite frankly, your local government. They don't necessarily care about coming in and looking at it, but I have had threats from municipal entities coming back and saying, well, this violates, what you're doing here violates the landscape plan, so you have to come back and get it amended. Well, how do you amend a landscape plan? It's kind of like a plat. It would require 67% approval of the owners in the community. But again, these are all just kind of some of the things that you need to consider when you ask, can we be more restrictive than these documents? Then, of course, we finally, after we drill down all of those other fun documents, your governing documents. What is usually referred to as your governing documents? The declaration, the articles of incorporation, the bylaws, the rules, regulations, policies, and procedures. You work through those in that order to find out which one supersedes, which one trumps, and as far as what do we have to change to get where we want to go. Okay. Another thing I think that sometimes we lose sight of is, where do we get our powers to begin with? Or where does an association get its authority to begin with? And you've got to ask yourself then, well, I ask myself, what is a covenant to begin with? We refer to them as CC&Rs, conditions, covenants, and restrictions. We refer to them as the declaration of conditions, covenants, restrictions, easements, and agreements. A covenant is really nothing more than an agreement, convention, or promise of two or more parties by deed in writing. And that is, the by deed is very important because, one, it has to be written, and two, it has to be in a deed, which is recorded in the real property records of the county upon which the property is located. And the covenant really is intended to, it's a promise that the owners make to the association and the association makes to the owner on how to conduct your business, how to live your life. You are taking some of those rights away from an owner of the free, unfettered use of their property in exchange for the association's promise to maintain the common elements, the association's promise to maintain insurance, the association's promise to enforce these restrictions against everybody in the community. So we do need to understand exactly where these authorities and where these powers come from and why we think they're important. It's also important with that, a theory of a covenant is based in contract. This is one of the theories that when I move into a community that's a covenant-controlled community, I'm entering into a contract to act a certain way. And with that, the association is entering into a contract with its owners to behave a certain way, to make sure that it is doing what is set forth in the governing documents. These are restrictions on the use of land. So I want to do, again, just a real quick refresher on some of these things that we've been going through. The declaration or the covenants, the CC&Rs, they run with the land. Very important. That means they don't expire. They're recorded, unless they say they're going to expire. They're recorded, creates rights and obligations, establishes what the board can and can't do. It establishes maintenance and insurance requirements. It establishes the assessment authority. Use restrictions. And this is usually where the question comes up of, can we be more restrictive? Well, maybe it depends. Architectural review. Your articles of incorporation, they are the birth certificate of the association. They establish the basic purposes and powers of the association, the corporate entity. It has the initial board and the size. They're filed with the Secretary of State. And they handle the business aspect of life. Okay, your bylaws. They are an operating manual for your board of directors as to how they are going to conduct their business. So you've got the governance procedures, the membership requirements, the meeting requirements, voting, who gets to vote, how they vote, election of board members, the standard what are your board requirements, your board qualifications? They need to be in your bylaws. The statute only says that to be on the board, you have to be a person, which means you're above 18. There's no other requirement for a board member. So any other requirements for your board are going to appear in your bylaws. Your general powers and duties of the board. What do they do? Okay. Your rules and regulations, and this is typically, as we go through this process, it's usually in your rules and regulations that people say, well, can we have this in our rules and regulations? Can we put something in the rules and regulations that is more restrictive than X, Y, or Z? And this is where we need to do a really quick analysis, a real clear analysis of what is out there, what you are doing, and where the provision is that you're trying to be more restrictive, or the provision is that you're trying to be less restrictive of. Where is it? And it's usually modified in your rules and regulations. So these are typically established by the board. They are behavioral regulations. They implement what is in the other governing documents. These documents are the lowest in the chain of priority. So everything in this document has to comply with or be based in some other document. It's a clarification and supplemental abuse restrictions. They cannot contradict or conflict with the declaration or other governing documents or the statute. It's very important that nothing in these documents supersede or expand the authority of what is in the higher ranking documents. And then you see I've got this in big caps because it must be important that everything in a rule must be based in the declaration. It must be reasonable. A declaration, a covenant, does not necessarily need to be reasonable. Everything in your rule must be reasonable. A court will not uphold it if it's not based in the declaration and reasonable. I'm going to let that sink in for just a second. Okay. So this is the meat of the presentation. Of course, your controlling statutes, when you say, can we be more restrictive? Well, you've got to ask yourself, okay, what do you really mean? What are you trying to be more restrictive of? And you have controlling statutes that establish limits, such as whether or not an association can be more restrictive is based upon how the statute is drafted or how the ordinance is drafted. Does the statute set a standard? Okay. Does it state something like you must do this or you must do that, or anything you do shall be this? Such as an amendment to the declaration. Kiowa states that any requirement to amend greater than 67% is void as against public policy. Okay, so you have a standard, 67%, nothing greater. To be more restrictive than that, to say 75%, which is how older documents read, that would be void as against public policy. Can you be more restrictive than that? Absolutely not. The statute says anything greater is void. All right, so you can't be more restrictive than that in a voting requirement. Interest rates. Kiowa states that anything greater than 20% is void. Again, void is against public policy. As with amendments, you cannot be more restrictive. And I get a lot of questions from communities saying, we need to find a way to compel people to pay. And quite frankly, 21% interest is not compelling based on the level of our assessments. It is just the cost of doing business. Is there a way that we can get people, entice people to pay? The answer is, again, maybe. It depends on how you function it. It depends on how you deal with it. But any attempt to charge interest greater than 21% is going to be void. The other statutory limit in that is the usury statute, which adds any interest, late fees, or other costs that are associated with collection that exceed 45% are deemed usury and unenforceable. So when you get down to it, when you say, okay, our assessments are only $500 a year, 21% of 500, you're talking, $10, $12 a year in accumulated interest. It's really not helping us to get our assessments paid. So we threw a $50 a year penalty on it. Well, $50 a year, that's 10%, plus you're charging 21%. So then all of a sudden you're up at 31% cumulative interest. All right, you're probably still okay. But then if you charge a late fee in addition to the interest, and then in addition to some other fee that you're throwing into there, and it goes up to that past that 45%, you're really probably not going to be able to collect all of those monies that you're charging, and it becomes problematic. So you have to be mindful that there are these statutes, but again, there are cumulative statutes. So the question of are we more restrictive or can we be more restrictive is really problematic in collecting assessments because, again, Kyle establishes a cap and a limit. You can't be greater than that. The solar statute. And the new solar statute establishes baselines. Use of the 10% rule, what I'm calling the 10% rule. Your rules can't violate this mandate. So you can have all these wonderful rules that say the solar panels must be adjacent to or flush with the roof, and they must be embedded to this, and they have to do this, and they can't be here, and they can't be here. And somebody comes up and says, well, I want to install solar that's sufficient for this house, and your rules, implementation of your rules is going to be greater than, it's going to increase the cost more than 10% or decrease the efficiency more than 10%. Obviously, those rules are now void. So you are no longer able to be more restrictive than the statute, which historically the statute just said you could have you could consider architectural guidelines as long as you didn't effectively prohibit them. Now you've got standards. You cannot be more restrictive than these standards. Signs. You know, we kind of went through this last week too. You cannot be more restrictive and prohibit signs entirely. You cannot be more restrictive and reduce signs to such a size that they can't be seen. Your rules implementing the statute, as I mentioned, have to be reasonable, but you can't be more restrictive than this provision because this provision, again, states freedom of speech is utmost importance, and anything to the contrary is void as against public policy. So you run into these problems. Now, as we go through this, I would like to, and please, type in some examples of what you really want to do. A lot of times we get questions on pets. Well, let's find out what they talk about pets. Your county ordinances will vary, and it really is up to your county ordinances. However, as a general statement, the county regulates the manner in which pets are kept and not necessarily the numbers. So can you be more restrictive? Let's say Douglas County allows for up to 5 pets, but it's just that. It's up to 5 pets. Can you be more restrictive than that? Of course you can. As long as you're putting it into your declaration, allows you to regulate pets, and then your rules carry that forward. You are allowed to be more restrictive than that ordinance. Okay, and we've got a question. Can we still be restrictive on the number of signs per home? Yes, the question is, can you be more restrictive on the number of signs? Yes, well, as I mentioned, the statute says you can control the number of signs. You can't be 0. Owners have an absolute right to display a sign. Can you keep that sign at 1? Yes. Can you keep it at 1 sign and 1 flag? Yes, you can. Can you say 2 signs? Yes, you can. Now, we get into how about something along the lines of, let's say your declaration says everybody can have a for sale, for rent sign, and then you adopt a policy that says no more than 1 sign per home, 1 sign and 1 flag per home. Does that mean when somebody's selling their property, they can now have a for sale sign and a regular sign, a sign that says another message? Well, no, I don't think it does. I think you can be restrictive and say that 1 sign is 1 side, period, of end of story, regardless of content, because as we have beat on you and as we have preached to you, you cannot restrict signs, or you cannot regulate any content of a sign. And if you say only 1 for sale, for rent sign and no other sign, that's then all of a sudden you're regulating content of that sign. So you really have to control just the number at any time. 1 for sale, 1 for rent sign, period, end of story. Now let's say you want to allow somebody to have a sign and a for sale sign, a regular for sale sign and a normal sign, really what you've just done is you've said you can have two signs because you can't get at the content. If I don't want to put a for sale sign, even though my house is on the market, I just get two signs and I can say whatever I want to say. Okay. I'm dealing with parking trailers, parking in the community. The boards have been told because the community does not own the streets, they cannot govern the parking on the streets. Correct or not correct? And I'm telling you again, that's going to get down to very document specific. It's your document can say, your declaration can say, no parking on the streets and the streets are public. That may or may not be enforceable. In Parker has come out with an ordinance and said, only these 5 communities can regulate parking on public streets. Nobody else can. We, Parker, have said anything in a declaration that says no parking on streets is void. Only these communities can do it that were created prior to us adopting this ordinance. Okay. So again, if you're in Parker, I can't necessarily tell you. If you are in, say, another community, the theory is, and here I'm going to get into some really high level law for you for about 2 seconds. Again, take it for what it's worth. This is where you're really going to have to call your attorney. There is a theory that if the streets were made subject to the declaration prior to their conveyance to the county or the city, then you can regulate parking on the streets. If, however, the streets were not made subject to the declaration prior to their conveyance to the city or county, you can't, because then they're the city and county streets and you can't enforce something on the city. You also need to look at the way the community was created. And typically this comes in a single family detached type community or a townhome community that has public streets. A developer, when they build a community, they record the declaration and then they phase the community in. So they only bring in the houses as they sell, right? Standard practice for a developer. The streets have never been made subject to the declaration. If you look at your legal description, or if you look at the description of what's in the community, it's usually lot and block. So it's blocks 1 through 80, or lots 1 through 80, block 2, blah, 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 community. Well, then those streets were never made subject to the declaration, so you were never able to enforce on them because they're not subject to the deck. So it becomes really problematic. Now, I had mentioned you have a contract. Remember, go back to the very beginning. A covenant, it's an agreement between parties. It's written. It's in the same manner of a deed. And if your covenant says you cannot park on the streets, does that give you a course of action to potentially fine somebody for parking on the streets for violating the declaration provision? And my argument's no. It's since you have no enforcement capability over the streets anyway, you have no real authority to sit there and fine people or violate people for parking on the streets. It becomes very problematic. If they're private streets, go nuts. They're yours. They're common areas, common elements, and you can have whatever you want to do. So the bottom line is, generally speaking, if they are public streets, no, the association really can't enforce on those public streets. Now, the question has kind of not been resolved nationwide. It has really not been addressed in the state of Colorado. So we have no real good case law on it. So it's usually again, depending on how the documents are written and depending on how the declaration's written, not to try and enforce parking on the streets, particularly if you're trying to tow. Boy, never tow from a public street. As a matter of fact, I don't even think you can get a tow company to do it. All right, so we talked county ordinances will vary. However, as a general statement, the county regulates the manner in which pets are kept. As codes rarely discuss weight, association can fill that gap in. The only thing usually, and again, usually depending on where you live, the only thing the county codes or the city's ordinances will state is you can't have more than 5 pets. You can't have more than 4 pets. You can't have certain breeds, breed restrictions. For those, you can, for breeds, weights, that type of stuff, you can absolutely be more restrictive. You are authorized to, or you are able to put, now, getting back to where does this go? Well, if you are going to establish a weight restriction, you best be having that in your declaration. It's a use restriction. You're telling somebody what they can and can't do on their property. All right, county ordinance vary, however, is a general, okay, we talked about that. Jefferson County, and this is actually Jefferson County's definition of a dog at large. A dog at large is a dog that is off the premises of the dog owner, so it's not on their property, not under the control, and the owner is observed to be within sight, or the owner is not observed to be within sight of his or her dog. Okay, so if the dog is not under the control or the owner is not in sight and it's not on their property, that's deemed to be a dog at large. You guys, as boards, you as managers, can encourage adoption of rules that goes much more restrictive at that, because I could be sitting on the corner of my property, my dog could be running all over the community, but I'm there. You can see me. You can see my dog on the end of the block. I'm there. So that dog necessarily isn't at large if my dog has verbal recall and all I have to do is whistle and bring that dog back. That dog could be running around on everybody else's property, not my own, but it's not deemed to be a dog at large or a dog outside of my control. The association can be much more restrictive in its definition. You have a contract with the owner, and it deals with how you guys act. So can you have a restriction that says pets must be under leash control at all times? Absolutely, you can. You can absolutely also state that some communities prefer to have off-leash privileges and say it just has to be under control. Well, it's still a little bit more restrictive than the dog at large, which Jefferson County will act upon. But in your case, you are making the owner at least have immediate control of that pet, and it has to be next to them. You can adopt these provisions now. Like I said, where do they go? Well, if you're going to try and tell somebody how big a dog they can have, well, that best be in the declaration. Or the declaration better say something along the lines of dogs may be kept pursuant to or subject to reasonable rules and regulations adopted by the board. And the association is given specific authority to adopt resolutions or adopt rules regarding the keeping of pets. And it could be the number of pets, a reasonable number. It could be the size of pets. It could be, again, under immediate leash control, physical control of the owner at all times when on the common elements or off the owner's property. You have to be able to have again, getting back to the basis of this, you have to have the ability to adopt a rule, or it has to be in the declaration. I hope that makes sense, because again, this is kind of a topic that, again, it keeps coming up a lot. All right, here's your vehicles. And I forgot, Lakewood. Here you go. Lakewood says you can have up to 7 vehicles, including trailers, boats, and recreational vehicles, are allowed on each single-family residential property. 4 vehicles per unit are allowed on a duplex properties. The total number of vehicles allowed can include up to 2 inoperable vehicles. There you go. And it goes into C, inoperable vehicles for storage requirements. Okay, so Lakewood says you can have up to 7 vehicles, including trailers, boats, and recreational vehicles, allowed to be parked on everybody's lot and everybody's property. Okay. It also says they can have inoperable vehicles. And I think you guys see on a regular basis, communities be more restrictive than that, because it says up to 7 vehicles. It doesn't say each owner shall be permitted to have 7 vehicles. It says up to 7 vehicles. You, in your declaration, can further restrict that. You, in your rules, can further restrict that, as long as you have the ability to enforce that moving forward. All right, a couple questions. Let's go. What about Aurora? I did not look at Aurora. Sorry. I went ahead and I just looked at the jurisdictions around here. We can absolutely look at Aurora. We would just have to find out kind of how they handle certain things. Clarification: Republic Streets, standard single-family public streets. When dealing with a homeowner who says the HOA is not performing its enforcement duties because it's in our covenants, commercial, recreational, etc., can't park in the streets. Your suggested reply. I think the suggested reply is, again, it's in your covenants, but now, like I said, in answering that, we would have to make sure your governing documents aren't set up that you are potentially allowed to get it parking in the streets. Now, that being said, as I mentioned, more than likely you're not. So I think the question then becomes is that particular provision has been deemed to be unenforceable for whatever reason, and we can come up with good language stating why it is unenforceable, because you are not permitted to enforce on public streets. Depends on the jurisdiction. Like I said, if you're in Parker and you're in one of those communities that's specifically permitted to, I may not be able to make that statement. This is where we have to look at the documents and we have to make sure that we are correct in what we say. But then the response is, notwithstanding the provision in the declaration, since the streets are not part of the community, we cannot enforce against it. That's really the response that comes out and how we handle that. Okay. So as I'd mentioned, kind of getting back to, parking on the public streets, as this sets a maximum, the association can adopt more restrictive parking rules if it's permitted in the declaration. And you have to have that provision in the declaration regarding no derelict vehicles, no recreation vehicles can be parked or stored in the community. You cannot live out of a recreational vehicle when it's in the community. That type of stuff. Okay. The bylaws, and do you have any other questions real quick before I go into the bylaws and kind of some of the more restrictive provisions of where you go? And quite frankly, some of these are less restrictive than what the defaults are in Kiowa. Say Kiowa quorum is 20%, quorum is 10% in the Nonprofit Act. Can you be less restrictive than that? Yeah, absolutely, you can be. You just have to amend your bylaws. Board of qualifications, as I mentioned earlier, to be a person. Can you be more restrictive than that? Absolutely, you can. We put in board member qualifications all the time. Have to be current in assessment. Can't be suing the association. If you have to be an owner to be on the board. I mean, that's usually the most common. These must, though, be in your bylaws. You can't do these by rule. Notice requirements. Actually, the Nonprofit Act says, if you've ever actually read, if you're a non-Kiowa community or a community that's exempt from the provision of Kiowa, the Nonprofit Act says notice just has to be fair and reasonable. And it goes into what fair and reasonable notice is. Mailed 3 days, published in a newspaper, that type of stuff. Kiowa, of course, always says no less than 10, no more than 50 days from the date of mailing. So again, can you be more restrictive than that? Say, we want to go 60 days. No, you can't. This range, that's all you can do. And it says, does this change if you're are managing a metro district, not an HOA? Yes, actually it does, because a metro district has authority over public property. And the metro district probably can enforce its rules regarding parking on public streets. I would check again, because that's got the governmental entity aspect, and those streets are probably owned by the metro district, because the metro district's the one that maintains them. So it's in here. You've got a matter of the enforcing entity actually owns the streets, or the streets were conveyed to like I said, the metro district. So look at that again. That's going to be really document specific. Going to have to figure that one out. Okay. All right, we've got, I'm dealing with parking trailers, parking in the community. The boards have been told because the community does not own the streets, they cannot govern. Yeah, like I said, yeah, it's kind of gone down. I think that's a duplicate question. Yeah, that's, I have no doubt that that's exactly what the board was told. And if you need to respond to it, ask the attorney that said that, where they came up with that conclusion. And it may just be getting an opinion letter and then saying, dear owners, we had the association look at this, and this is what the association's attorney came up with, and this is why we can't enforce on the streets. And a lot of this is, again, because of court orders. So it's how the courts have now interpreted things. Okay. So, and getting back to, again, to the bylaws, most statutes defer to the bylaws. There's unless otherwise provided in the bylaws, or, this is how you do it. So that's why a lot of times in the bylaws or regarding those certain things, yes, you can absolutely be more restrictive on how the corporate entity conducts its business, because much of the statute defers to the bylaws. Really, a lot of Kiowa defers to the much of Kiowa defers to the Declaration as well. It's just a matter of finding those sweet spots where Kiowa does and where Kiowa doesn't. And Kiowa has very hard, meetings shall be open to all the owners. Meetings shall be this. You can't do this. You can't do this. These are the type of things that you must look at. Can you be more restrictive on how documents are inspected? No, you really can't, because Kiowa is very specific on how documents are allowed to be inspected. Okay. Okay. If a unit is owned by a corporation, may someone from the corporation serve on the board? Typically, yes. Your bylaws are going to say exactly who can serve on the board. And usually they say in the form of corporate ownership, it can be an officer, a director, officer, owner, usually not just general employee. But what you should also get for every corporate owned unit you have in the community is a statement of authority. Who can bind that unit? Who can vote for the unit? Who can serve on behalf of that unit? And typically, like I said, your bylaws should establish exactly who does that. But yes, that is something that you can, well, there you go. You can be more restrictive on that. You can say only the president of the corporation can serve on the board. Okay. As opposed to the president, any officer, any director, employee. So you can be more restrictive on that by establishing who can serve on the board or who can vote. You can state that it has to be the president of the corporation that can vote. That's perfectly acceptable. As we go down that path. Any other kind of questions relating to, this topic got so big that I kind of, had to pick it up and go very high level. Same for trust. Usually it's just the trustee. And the trustee is the one that can bind the property. The trustee is the one that can vote for the property. The trustee can serve on the board, because typically speaking, the trustee is the one that owns the property. They hold it in trust for somebody else. So that's how that works legally. So yes, the trustee can absolutely serve, but it's limited to the trustee, not the beneficial owner or not the beneficiary of the trust. Okay. So let's talk about other areas that you could be more restrictive in your rules or in your regulations. Most fire marshals state that you have to inspect, in multifamily housing, you have to inspect your fire alarms annually. If you live in Denver, you know this. Or if you manage a community in Denver, you know this. Can you be more restrictive and require that be done more often? Absolutely you can. Can you be more restrictive? We talked about dogs. Can you be more restrictive on uses in the community? Absolutely you can. You can, now, I'm going to throw a caveat out there, of course, with federal law, but can you restrict the unit to, well, rentals? Can you restrict an owner can you prevent an owner from renting their unit? Yes, you can prevent an owner from renting their unit. But again, it's a use restriction, has to be in the declaration. Can you restrict an owner's length of leases? Yes, in the declaration. You can't do this by rule. And we had this conversation when, short-term rentals came up. The fact that you've got something in there that says units may only be used for single-family residential purposes and no other reason, that does not prohibit an owner from renting a unit. And that does not prohibit an owner from using the unit as an Airbnb. That has to be in your rules, or not in your rules. It has to be in your declaration that it can't be used for short-term transient rentals, can't be used, initial leases and occupancies must be greater than 30 days and the like. So you kind of see how that's going. Is if it's a use restriction, can you be more restrictive than local code? Yeah, probably you can. It has to be in the declaration. If it's implementing something that the county puts maximums on, parking, I can have up to 7 vehicles on my property. Well, you need a rule that says, or you need something in the declaration that says parking can be restricted by the association, and then the rule that establishes these parking rules. It's these other things that you have to deal with. Can a unit owner in a condominium association restrict access to his unit for annual fire alarm testing? No. You have an easement to get into that unit. And they cannot restrict you. They cannot tell you you cannot come into the unit. Now, when I say that, I don't want you to just go pounding into somebody's unit for routine maintenance, because right now the nature of this country and what's going on and what people are doing, I don't want you just pounding in, just going into the unit, announced, unannounced. You could schedule it, and if an owner said, "Do not come into my unit," I don't necessarily want you going into that unit. I want you to make sure that you have permission from the owner to go in, even though you have an easement to go in. I dealt with Sandra. I dealt with this just yesterday, 2 days ago. They were doing the annual fire alarm testing, and owner said, "I'm a full-time resident. Do not come into my unit. I have a gun." I advised the manager, do not go into that unit unless you are invited. They open the door willingly, and you are invited into that unit to go perform your inspection. I also said what we need to do is send this particular owner a letter explaining our easement rights and explaining the fact that if they deny us access, we are going to go to court, and we're going to get a court order, and we're going to have the sheriff serve it upon you, and the sheriff is going to allow us to come into this unit and do the fire alarm inspection. And guess what? You're going to pay for the $5,000 extra that it took to get into this unit, because we have a valid easement. Do not just go into a unit. Just don't rely on what's written in your document. People are not rational right now. People are not, they don't care what's in the document. They only care what they feel, what they believe is right. And like I said, in this particular case, owner said, "I have a gun." I'm like, do not go into that unit. I don't even want you going into it, because it's not worth risking anybody's health. We will just go to court and charge the owner with all the costs on that. So no, they can't technically do it, but if they do it, we have to go around the procedure to make sure we get in. Okay. In summary, as we go down this, let me see, blah, blah, blah. We did that. Okay. When looking at if you can be more restrictive or not, you have to ask your baseline questions. Does the statute code fully address the issue? Does the statute say this is how it is? If the statute says this is how it is, this is, shall be permitted, shall do this, you shall permit a sign, you shall do this, that means the statute's fully occupied the issue, and you cannot be more restrictive. You can't be more lenient either, for that matter. Was it intended to be all-encompassing? Or was there fuzziness in the statute, like the dog? We consider this a dog, or we consider this dog to be at large. Okay, that's their definition. You can have a different one. You can have up to 7 cars. Well, that's what Lakewood thinks is acceptable. You can be more restrictive. Lakewood, I think, or most of the jurisdictions say garbage cans have to be brought in after X number of days after collection. You can be more restrictive. You can say 10 minutes. You could say 24 hours. You have to be reasonable. But again, you kind of get the gist that you can be more restrictive when there are outside limits. There are. Are there areas that weren't addressed in the statute or in the ordinance? If there are areas that weren't addressed, yes, you can fill in those gaps with rules. More than likely, though, some of the stuff you have to have it in your declaration. Is the provision in the declaration most likely? Let's say, and here's the thing. As I mentioned, is the provision in the declaration most likely? A declaration provision is going to be upheld unless it's discriminatory in nature. You can't discriminate in your declaration, but everything else, as long as it's uniform. A declaration provision usually does not even have to be reasonable, because it is recorded in the real property records. It is voted on by all the owners. It's a contract or a covenant that all the owners enter into. So therefore, you have that ability to enforce that contract, enforce those contractual terms. If it's in the rules, rules are adopted by the board. Rules are subject to change. And if rules are subject to change, courts hate the up and down nature of rules. If on one day you can have 3 dogs and the next day you can only have 1 and the next day you can have 7. Your rules have to be reasonable. And the courts are going to pick those apart. They have to be clear. They have to be reasonable. They have to be based in the provisions of the declaration. If they are not clear, if they're not reasonable, if they are not based in the declaration, the court is going to lean towards the unfettered use of the property, not the other way around. It's not going to enforce the rule. Ran into a situation just the other day where a court the association had been acting in one way regarding maintenance of the windows, and they'd been acting this way for 25 years. And the court looked at it and said, you know what? I'm not convinced. And since I'm not convinced, I'm going to say that the windows are the association's obligation, even though they had never been budgeted for, never included in a reserve study, never, they had multiple attorney opinions saying go the other way. The court said, nah, I'm going this way. It made it a little interesting. Okay, so let me see. Can we still be restricted? Oh, restricted. Okay. If hot tubs are allowed per the rules and decks, can an HOA change the rules that no hot tubs are allowed and the homeowner has to remove the hot tub? Okay. You started with if hot tubs are allowed per the rules and deck. Okay. Well, if they're allowed in the deck, you cannot prohibit them by rule. You have to amend the declaration to restrict them. You have to amend the declaration to get rid of your hot tubs. Then no future hot tubs will be permitted. And when the individual hot tubs that are existing now break, they can't be replaced. Can you make somebody remove an existing hot tub? Absolutely not. You can't. There's a 1-year statute of limitations on building restrictions. A hot tub is considered a building or a fixture or an attachment to the property. You cannot require them to remove that hot tub. That's not reasonable. When the hot tub breaks, it can't be replaced. Absolutely. You can also state depending on the type of community, you can state noise from hot tubs can't be unreasonable. And if it's heard from the property line, it's deemed to be unreasonable. So you can make it so that almost that they can't be operated. But again, you have to be reasonable there. And I know a lot of these situations, the hot tubs we represent a community that's a stacked community with balcony hot tubs that are leaking all the time. And we have just made it so burdensome that everybody's starting to get rid of their hot tubs so they're not filling them anymore because we are assessing any and all damage caused by the hot tub to the hot tub owner. There are ways to address it, but no, you cannot just force removal. If I want to keep my tub and I will take all the risks associated with it, it's my prerogative. I can do that. Okay. Well, that's all I've got for you guys. I'll stick around for a few more minutes if you have any more questions, but thank you so much, everybody. As always, been an absolute pleasure. And this is going to be, well, you're not going to hear from me for a little while. This was my last class of the year. So again, I thank everybody for joining me and having a good time. And like I said, I'll stick around for, about 5 more minutes if you have any more questions. I can start making up questions too. Okay, here we go. Oh, if smoking is not addressed in the declaration, can a rule be created to restrict smoking outside of a condominium complex? Yes, you can adopt a rule stating that because you can adopt rules on the common elements, no smoking anywhere in the community other than in the units. You cannot restrict it in the units because, again, that becomes a use restriction in the unit. You would have to amend your declaration. But as far as the common areas, absolutely, go nuts. You can restrict smoking anywhere in the community. Okay. Let me see. Where do we go now? Thanks. So thank you, everybody. You're the best. And I do thank you so much.